Hello together and welcome. I'm very pleased to welcome you to our Televesing webinar regarding the new standard contract clauses. My name is Mareike Germann. I'm Surrey partner at Televesing and specialist in IT law, also with focus on data protection. And I'm very pleased to guide you through our event with all that data protection experts here at my side. First of all, I would like to introduce our guest, Aaron Vella, President of Sentinel, a provider of contract management solutions. Aaron leads the privacy consulting practice and is a thought leader in the field of privacy in the US. So welcome. Further, I would like to introduce my colleagues, Axel von Busche and Chris Jeffrey. Both are partners in our offices in UK and Germany and are absolute experts in data protection as well, and especially with a focus on data transfers. So before I give the start signal to all the three men here at my side, let me give a short introduction. The EU Commission published the new standard contract clauses on 4th of June. And well, we all have certainly been waited for that. But we all hope that they will simplify our lives. But is that true? What are the changes in the new standard contract clauses? What are the deadlines? What do we all have to do now? So these are only some questions. We are sure you have also some. So don't be afraid, just put your questions here into the chat. We will answer them. And now we will come to the first presentation. Axel, it's your stage.
Thank you very much, Mareike. Yeah, yes, indeed, we are very excited. We are all very excited. I'm not 100% sure if this is a good sign, if lawyers are excited with something, and we will shed some light on our excitement here. First of all, just jumping in, as Mareike said, they were announced on the 4th of June. However, the new SCC were published 7th of June, and this is when it all starts. From the 7th June onwards, there is a 3 months period until 27th of September, where you still can use the old standard contractual clauses, however, with necessary additions, which are necessary these days. And after that, from 27th December 2022, 2021. You have another 15 months period, after 27th of September 2021, you have another 15 months period where you have to replace all clauses. What does it mean in practice? That means that in the first 3 months as a company, you need to get accustomed with those clauses. And you have another 15 months to replace all existing transfers. I must say, this is a rather short period because the clauses are very complex. I mean, all of you who are listening today, it's a good sign you start right away to get your head into the clauses and get a feeling how they work. I can say they are pretty complex to implement. So I think you definitely need these 3 or at least 2 months to have a template which suits your business. And then for the next 15 months, depending on the size of your company, once you have done a data mapping, could easily be that you have 1,000, 5,000, 10,000 agreements, far more data processing agreements or data transfer agreements than you expected. And then you still, once you have mapped those contracts, you still need to switch and change into new contracts. This is a heavy duty. It's not that you just press a button. You need to find your contracts. You need to find your contractual partners. You need to partly negotiate where necessary, or at least convince your partners to go into that clauses. But this is practical approach we will discuss later. First of all, so that you get an understanding about what's going on, the new standard contractual clauses, and that's brand new. They're following a modular approach. We have controller to controller, we have controller to processor module. This is what we knew from the past, from our old standard contractual clauses. However, now we also have processor to processor clauses. This is something the world was waiting for. This allows, let's say, a better and more easy contracts down a chain of various processors to subprocessors. And then we have a new kid on the block, processor to controller. However, this controller must be outside of the scope of the GDPR. I come to that later. This is a new module, and we're not really sure if this is a module we are looking for. So what does it mean, these new modules? First of all, first finding different to what was necessary in the past. There is no additional agreement pursuant to Article 28, subsection 3 GDPR required for module 2 and 3, controller to processor and processor to processor. This is a very good news because this put some uncertainty and additional burden in the past, but now we have a stamp on it, officially approved. If you have standard contractual clauses between controller and processor, and or processor and processor in place, there's no requirement for an additional DPA. As I said earlier, we finally have the long-awaited constellation processor to processor. Then this is this question mark, and that relates to module number 4, processor to controller. This could lead to, let's say, disadvantage to European processors, because if you are a controller outside of the EU and outside of the scope of the GDPR, why on earth you would instruct a processor of the EU who is more or less infecting you with the GDPR if this is not necessary? So we believe that this module 4 could lead to more, let's say, a competitive disadvantage to EU processors, because those controllers who are falling under that clause will rather likely go somewhere else. But we will see how this will work out. Another good news is that you have multi-party possibilities for both data importers and exporters. That means you have docking clauses. People can just be very easily, by more or less signing the same agreement, go under this agreement without the need to have additional separate agreements to conclude. That hopefully facilitates the handling of those contracts. Last but not least, choice of law and jurisdiction. You can choose whatever you want within the EU. I think it's an interesting clause. I'm not personally 100% sure how this will work out in practice. If there is some law within the EU which maybe is more positive, grateful, easier, let's see how this pan out. So that's a good one. And here I need to go a step back if time allows. Let's have a quick look. Yes, time allows so, and a little bit more light here. Relevance with regard to Schrems II judgment. This Schrems II judgment, let's say there are two factors which are relevant with the new SCCs. The first one is the old SCCs are from 2001, controller to controller, and 2010, controller to processor. They had been outdated. They were not fit enough for the GDPR. So it was just a question of time that they need to be replaced. Originally, they should have been replaced with the GDPR altogether, but the Commission was a little slow on doing so. That's one bit, so general modernization and compliance with the GDPR itself. And the other big chunk, which really makes the new SCC different, is the famous, unfamous Schrems II judgment. Because with Schrems II, you might remember, came along quite a lot of additional requirements for the party. These new standard contractual clauses now embed all these requirements set out by Schrems II, and the Commission was wise enough actually to wait. The Commission knew that Schrems II was going to come out, and they waited with their new standard contractual clauses in order to have the chance to embed everything what was already anticipated now also in the new standard contractual clauses. The good news here is that most of you had been working with the recommendations of the EDPB, of the European Data Protection Board, how the authorities understand the Schrems II judgment. I must say the EU Commission is a bit more generous than the compared to the EDPB. It allows a little bit more flexibility. It allows more of a risk-based case-by-case approach, whereas the recommendation of the EDPB, to cut it short, was for Schrems II, they more or less said all data transfers, in that case to the US, will not meet the US, and this applies to all transfers, regardless of the particular circumstances, is never a country with adequate level of data protection. So always additional measures are to be taken. New standard contractual clauses are not saying this. They say you have to assess on a case-by-case basis. And the second bit, which is relevant here, is that the EDPB said you always need at least technical requirements. Contractual organizational requirements are never enough. And this is not taken on board by the new standard contractual clauses. To the contrary, if you go to section 14, I just hop here because I'm already on that slide and going back in a second. This clause 14 is mostly relevant. This is the kernel of Schrems II, probably also clause 15, but this is where you have the so-called transfer impact assessment embedded. This is where you really have to dig yourself deep into it and to find, is my transfer in question? How can I how can I assess my transfer in question to a particular third country under clause 14? And the good thing is, at least, I think it's a lot of work to do it properly, but at least the new SCCs allow us to create a defensible position. At least it allows us to work hard on it and to somehow document a situation where we say, we did our math, we did all what we can, we assessed this very situation, and we came to the conclusion it's feasible. And now I know Mareike is there. That's always a good sign, but it also means I had to stop talking just to see if I need to address something which is important here. Oops, now I'm doing something wrong. I rather stop messing up the slides. No, I do it very easy. I now hand over to Chris because my part is done, and he has to make sure that he finds back the right slides. How about that? Chris.
Thanks, Axel. I think that's where I come in. Thanks for the curveball. That's always fun on a webinar. Yeah, hi everyone. Chris Jeffrey from the UK office. So Schrems II, as Axel was saying, is really so much of the heart of the new standard contractual clauses, and where exporters and importers need to put a lot of their focus. There's also a lot else going on, and I wanted to touch on some of the other main points. So I'll rip through these, and apologies for being light touch and speaking quickly. Fixed character, they are, as we're familiar with from the current set of SCCs, a sacred text in Europe. So although you have the flex to fold the new SCCs in their modular form into an MSA or other commercial terms, or into a schedule or a separate document. I quite like that flex. Still, the clauses themselves are a sacred text, and we'll come on a little bit later to how I think vendors may still try to manage, so to speak, some of the rougher edges of them. Third-party preference, something of a change. How real this is in terms of risk, I think, is debatable. But data subjects essentially have the right to enforce against importers direct pretty much all of the commitments that the importers make under the new SCCs. And that's whether their controller in Europe, the exporter, has gone bust or not. So that's a change from the current SCCs. I think the thing to say is, class actions, group actions, compensation claims from data subjects are in their early stages in Europe. We have seen some claims against some of the US tech giants, against British Airways in the UK, for instance, for its data breach, just starting to get off their feet. Funding isn't straightforward, and so it's not the same class action risk you see in the US, but the SCCs make it that little bit easier. Hierarchy and liability, I think probably after Schrems 2, I would say this is the biggest point for the vendors, who happen to be the majority of the clients that I'm acting for. And that's that the way the hierarchy and the liability clauses work is that there's even a question mark now as to whether you can exclude indirect loss or limit your liability under the SCCs to a cap in the way that we're all used to. And the reason, very quickly, is Clause 7 says each party shall be liable for the consequences of their breaches, paraphrasing slightly. Then the hierarchy clause says any provision in another agreement which directly or indirectly contradicts the SCCs is void, and the SCCs govern. So you can see that what's new is that very stark statement, each party shall be liable. We haven't got that in the current SCCs. So every attorney, every privacy professional I've spoken to thinks there's now an increased risk. Of course, vendors are going to fight hard, and rightly so, I think, to float liability limitations off, but there's more of a question mark about whether it works. Docking clause, I won't spend a lot of time, but there's, I think, quite a practical, useful way of adding importers and exporters where they're involved in the same transfer for the same purposes. They can join the party, as it were, by signing an annex in the back. Perhaps more useful to, global customer deals where there's multiple affiliates and you want them all to be party, or intra-group where, internal data is being sent around a multinational group. Supervision, just very quickly, the importer submits to the authority of the EU regulators. Quite what that'll mean in practice for people who are technically outside their direct jurisdiction, I don't know, but it's a little bit more uncomfortable perhaps for some importers. And there's a way that the regulators may get more involved. If an importer thinks that they cannot comply with the clauses, bearing in mind there's a lot of detail in there, then they have to tell the exporter. Then the exporter has a bunch of options, either to see if they can make changes, or if they can't, then they should just terminate the transfer. Either way, the exporter needs to tell its local supervisory authority. So I think there's a mechanism there. Of course, we'd hope it would never happen, and no doubt importers will apply a high bar to that notification. But there is the possibility, you can see, that we're used to with data breach, but not otherwise. There's a mechanism for the regulators to get involved in the nuts and bolts of these documents. Choice of law. Axel touched on this. I think for controller to processor and processor to processor, you either go with the exporter's law as we're used to under the current SCCs, or you have the option of going for any EU law that respects third-party rights. Again, with the objective of allowing data subjects to enforce the rights direct against the importer. You can't choose UK law because, as you all know, the UK has left the European Union. Irish law has a problem we found in talking with clients about this. Irish law doesn't technically allow third-party rights enforcement, so those two are off the table, which is an interesting development. Anyway, it'll be subject to the usual debates. Customers will still want their own governing law, and there may be compromised jurisdictions. But you've got to think, I think, a little bit more than we're used to. It's not automatic that it's the exporters' governing laws that'll apply. Right, I'm gonna rip through quickly, just in respect of time. So for what it's worth, my initial thoughts, there's some really good stuff here. I quite like the modular approach. I like the fact we've finally got processor to processor. We've got some legal certainty there. I like the fact that there's flex about how you fold them into other documents. I think that's actually really helpful. In terms of the timing, we're already seeing EU customers ask for these, even though they're not actually valid for another 10 days. And I guess I don't have a problem with people using them if they want to. I don't think you're going to get enforced by a regulator for using the new document a little bit early. But I do think vendors really need to hold off that request, because there's a lot of work to do to make this work in practice. It's not just a legal team effort to change your customer documentation. So for the US vendors, who are, the majority of my client base, there isn't much time. Your customers want these now. So we really need to get on with getting those templates ready. An Article 28 DPA has also been published. So standard contractual clauses for processors where no transfer has happened. And so it's an interesting point. I agree completely with Axel that where all data is exported out of Europe by a processor, then we would just use the new SCCs. Bit of a question mark, I think, that if, say, a vendor is using an AWS instance in the Netherlands or Ireland, so some of the processing is done within Europe, do we need a DPA and the SCCs in the way we're familiar with? Or is there some way of picking out the Article 28 elements that are embedded in the processor modules and using them? I think that needs a bit of thought. And as I say, and we'll touch on it in a minute, I think there's still room for vendors to try and manage some of the rougher edges. A quick word about the UK and Switzerland, not just from a patriotic perspective, but it's important to remember, of course, those two important markets are not part of the EU, and neither authorities in those countries have approved these new SCCs. It's expected that the Swiss regulator will. They tend to align pretty closely with Europe, but we don't know for sure. We know that the UK ICO will issue its own new SCCs. We heard soon. In another statement, it was in the summer, but we don't know when, and we don't know how close they will be to the European ones. But I think the hope's got to be that we will have, within a month or two, we'll know if there are any tweaks that need to be made for the UK or for Switzerland. So we should be in a position, at least that's my hope, we'll see, in a position to have a template that works in across the European Union and the EEA, but also in respect to transfers out of the UK and Switzerland too. Pain points and operationalization, I can't say it. Really key point for me is that for importers, there's actually quite a lot of work to do, particularly where you've got a lot of European business, to try and put in place the processes, whether they're automated or they're manual, so you can have consistent application, manage risk, comply with these clauses, and keep your customers happy. I wanted to go through a few of those quickly. Axel's touch on the third country assessments and information, actually under clause 14, deliberate error. And so the question, I guess, is for the vendors is, well, what should my pack be? I have some responsibility under these SCCs to provide information. You need to use best efforts to provide the exporter with relevant information. And we both have to warrant we've done the adequacy assessment. What does that mean in terms of the pack? I think that's got to be where you process. It's probably an assessment of the laws. And we've done that for a few clients already. And I think the key flag for me to be that the EEEGs, which are the standard you have to try and hit if you don't need supplementary measures, are a sufficiently high bar that I'd be quite surprised if any country in the world hits them, including, by the way, countries in the European Union, but they don't have to because they're deemed to be adequate under GDPR. So I think my sort of working assumption is, yes, we need to always summarize the law, but it'll be quite unusual to find a country, unless they're adequate already, I think, that really hits all of that very high bar threshold. Audit rights, interesting one and a common pain point for vendors. What these processor modules say is, right to information, audit at reasonable intervals, fine. Vendor certifications may be taken into account, which is helpful because often we say, here's a SOC 2 report. We do it on an annual basis. It gives you, the customer, the comfort you need. But I don't think that's going to be enough because these more detailed SCCs say it may include inspections at premises or physical facilities. Now, I do think there's legitimate room, although no doubt this will be negotiated, to build some kind of framework about the circumstances in which it is appropriate for a customer to say, I want to come to your office. Because for cloud vendors in particular, we all know that can be relatively meaningless. But still, with that provision in there, I think we need to leave room. It'll be interesting to see whether AWS, Google Cloud Platform, amend their standard sub-processor agreement to allow any kind of physical inspection in limited circumstances, a bit like they do to an extent under the EBA outsourcing guidelines in critical outsourcing for financial services companies. Right, I'm running out of time, so I need to get through this quickly. Sub-processors, that reflects Article 28, which is helpful because you can have a general authorization and objection process, but it does say there must be a specific notification of new sub-processors. So I don't think it's enough now probably to sit back and let your customers ask or visit a URL. I think there needs a positive notification. Security measures, I think the flag here is, yes, we have an annex at the back in the processor schedules where you summarize your security measures, and we're all used to doing that. But the flag is there's more detail now, because that annex includes a shopping list of 13 subheadings within security, really asking the parties to say, you really should have examples of security measures under each of these 13 headings. Encryption and pseudonymization is the first one. So I think on the one hand, that's it's not unexpected that they would push you to that detail, but it does mean you have to step through some of the specifics. The detailed language, I can see Mareka again, so I know I need to be quick. The detailed language actually gives you some useful flex. It doesn't say encryption is always necessary. It has a helpful little reference in there to say the parties must think about encryption, but it's not mandated where the purposes of the processing could not be fulfilled. And I think that's helpful because EDP guidance, use case 6, any transfer of data in unencrypted format to the US is likely to be unlawful. These SCCs give us room to argue against that, which I think is helpful. What to do, I'm going to stop here, but game plan is the biggest thing for me. I think this needs multiple teams, not just legal, needs InfoSec, needs sales, needs marketing. It's a project with multiple work streams and not just a contract tweak at the front that the legal team can do and slip out. It will have, at least for a few months, an impact on sales lead times as well. So I think you need to get your sales teams trained. They need to know what's going on. They need to be able to talk to the corporate approach to these new SCCs and any attempts that have been made to manage those rougher edges in the way that I was speaking about, and to talk, not as legal experts, but to talk with some authority, I think, to the Schrems 2 elements altogether. And with that, I will stop. Thank you.
Thank you, Chris. Well, before we go to Aaron, maybe here's one question that is the question for you. And it's not really about the SSCs, but are there any news on the EU Commission's UK ADC decision?
I haven't heard anything specific today. We are expecting and hoping that will hit at any time. And you know, the political pressure, I think, openly to get that agreed as part of Brexit, I think we'll probably see it through. But unless something has happened while I've been preparing for this presentation today, I don't have any specific news on a date for you. But we'll follow up if there is, of course.
So yeah, thank you very much. Was very interesting, and welcome, Aaron. So, well, at first we had the legal perspective, but now we get a practical view. So, what have to be considered organizationally? And yeah, welcome, Aaron. We look forward to your insights.
Thanks. And I think Chris set this up nicely with saying that there's a lot of complexity around deciding what needs to be done. But I think then that the real challenge is going to be actually getting it done. And this is not a new process. Although the SCCs have only recently come out, large organizations, particularly those that have operated in different countries, have had to go through this a couple of times over the last couple of years. When CCPA came out in California, there was a differential between a service provider versus a third party. And organizations had to say, well, do we know do we have third parties? Because then we'll have to create this do not sell button and all of the rights associated with it. So going back and looking at your contractual relationships, understanding the privacy implications is something that I think as laws continue to evolve and change, we're going to see this not just with the Schrems decision, but also as some of the other state laws coming in the US and in other jurisdictions as well. And what I wanted to touch on was really, you know, as Chris was really saying, thinking about how do you run this kind of process as really a project? Because you're going to be dealing with pretty much every part of the organization that's going to have contracts that deal with personal information, personal data in one way or another. And looking at how do we understand from a legal perspective and what are we actually going to do strategically, whether we are a controller or a processor. But once we've done that, there's going to be a lot of work to actually get these contracts updated and through that process of making sure that it align with your strategy and then stay up to date over time. And I think really that what my team has been doing at Sentinel over the last couple of years is to work with organizations, work with inside and outside counsel and say, we need to look beyond the contract to really understand the overall transfer process. And one of the things that we need to look at is not just where those contractual relationships exist with third parties, where the SCCs are going to be invoked, but also what are the ways that you are transferring data within your organization as well, and looking at these transfer impact assessments that have been called out in the EDPB guidance, trying to understand how are we going to do those, how are we going to sign off on the risk, how are we going to make this process efficient? Because as Chris said, going through updating contracts, negotiations with third parties where there is some wiggle room, even though the SCCs are largely set in stone, it is going to slow down the sales process, particularly as we get to the end of the quarter. That's going to be increasingly challenging to work with sales teams if you haven't had a really good change management process around that, where you've really got a project plan and executive buy-in. So our suggestion is really to pull together a project approach and think about the things that you can be doing now in parallel. One of the things that we've identified from working with large global organizations is that often the contract information itself has some work to be done to improve that quality up to the level that you even have active contacts for all of your contracts, right? If you've signed something 3 years ago, it may be that your internal contact or the external contract could have changed roles. They could have left the organization. Trying to negotiate these deals where You can try and go for an approach where you send every single vendor that you work with the same letter and say, please just update this, or try and take a much more nuanced approach. That's got to be part of your strategy as well. So really thinking about, how do we identify where all these data transfers are? Do we even have in our procurement systems, contract management systems, which relationships actually involve cross-border transfers? Because you may not have been thinking about this several years ago when some of those contracts would have been signed. So really thinking about what is that you can do today while you're still working through a lot of the information that Axel and Chris just talked about, really working into what do we really need to do. There are some things that are listed on the bottom of the slide here where you need to be thinking about some of that stuff and working on these pieces around the data, the actual contracts themselves, even while you can be working on the legal aspects at the same time. So really thinking through, in line with the EDPP guidance, how do you identify the scope of what you're looking at? What are these transfer mechanisms? Where do we need to look at the laws in the third countries? Chris was talking around, that are there countries, there are some countries that are adequate or considered adequate by the EU. We're still waiting on adequacy decisions for the UK in particular. But what does that mean for your strategy, given the timeline that we're dealing with as well? And then thinking about the supplementary measures as well. So the standard contractual clauses are not just the only thing you may have to change. You may need to go and look back at, does our data protection addendum overall, do the security controls that we require contractually, are they in line with the risk of the third party, the third country, and the controls that the third party has put in place? And then think about this ongoing process as well, because while this is one project with a particular deadline, as I said, over the last couple of years, we've been seeing this from different jurisdictions, and the need to kind of maintain an up-to-date understanding of what those contracts are is not going to go away. So even after this project has been completed, think about this as being something where you can build an efficient engine and then use that to accelerate future initiatives as well. And this is something that my team has been doing for a couple of years, looking at helping organizations from at the low end with a few hundred contracts up to contracts in the 5 figures, and really trying to go through and say, how, if we have thousands of contracts we need to get done, how do we do that in an efficient way that impacts the business as minimally as possible? So I think when you're going through and you've understood the legal side of things, also then really think about how are we going to deliver the project, and how are we going to have people who really know how to deliver projects. If you have a project management office already, or if you're using PMO resources from your IT function, think about who is going to be doing this piece of the work. Because you can imagine if you're sending hundreds, thousands of emails, there's going to be a lot of coordination required to make sure that everything gets done and you're not running into 5 people contacting the same vendor. So the project management piece is really important to supplement all of those legal decisions around what are we actually going to do. And just in case you haven't run across Sentinel before, we're based out of the Pacific Northwest in the US, but we work largely with Fortune 500 organizations. You can see some of the companies we work with here. And really a lot of the work that we do is supplementing. I like to say that we help lawyers get things done. So although half of my team are lawyers, we're not a practicing law firm. And really we're trying to be, that glue that really translates between legal requirements and then a lot of the rest of the people in the business that need to actually go and get some of these things done.
Yes, so thank you very much, Aaron. That was very interesting. Maybe one question from my side: what is your most important tip to deal with that challenge? What is the first step you think that's the basic of all?
That's a good question. I think the basis is really getting that executive buy-in, because as I said earlier, these contracts are going to be held in all parts of the organization. It's very, very hard from a privacy function or a risk management function to really be driving that unless you've got that communication up to the executives. And then that's really being communicated out to all of these people who are going to own these contracts. That really does lay the way for this change management piece that I mentioned, where you're always going to get people who say, well, I need to close this deal, I can't spend the time. And having that air cover is going to be crucial to project success.
Thank you very much. So we have some questions here. Maybe the first one to you, Axel. Will the authorities make the 4 individual modules available for you?
Sorry, that was. I see this. I was hooking on the first question actually from Dan.
So
if you allow,
you don't get to choose.
Let me hop on that if you allow, so because I have the answer already in the head. Dan actually asks if US undertaking who has no foot on the ground in the EU and simply is a website, not really marketing to the EU, and end customers buy goods via that website. Do this require SEC, yes or no? And I would say no, because Article 49 will apply. This is something which we haven't answered and which yet, or which we hadn't stressed yet. Of course, having new SCCs doesn't mean you always need to have SCCs. Why do we have standard contractual clause in place at all? This is to justify the transfer of the EU, that's Chapter 5 GDPR, from the EU into a so-called unsafe third countries. However, there are various alternatives and other justifications for that transfer, and there are some exceptions to those, and one of the most important exceptions are in Article 49. One could be consent, and another one could be the data transfer is necessary to conclude an agreement. So if they buy something over your website, this very transfer will be covered by Article 49, which doesn't mean, and this is the bad news, that you're off the hook of the GDPR as a whole, because therefore Article 3 subsection 2 applies. You said you're not marketing to the EU. It always depends. If your website, for example, has various languages, maybe European languages, then someone else would be of the opinion, you probably market to the EU, and then you fall under the ordinary GDPR compliance obligations via Article 3 subsection 2, which applies also for companies who have no foot on the ground in the EU. That's the huge exterritorial approach of the GDPR, which applies there. Then you even need an EU representative on the ground, but that's another story. Sorry, Mareike, you ask a question and I answer another one.
Yeah.
I leave this for Chris.
Yeah. So, but well, maybe you can answer that shortly. Will the authorities make the 4 individual modules available for use? Maybe we have a solution for that on our website for interesting users.
So let me see. Sorry.
Of our SCC generator, maybe that make it more easier when waiting for the authorities that they published, or for SCCs, or what do you think?
I mean, I'll jump in if you want, Axel.
Yeah.
I mean, so I think what we've got as with the old SCCs, we've got a decision from the Commission that says we've now approved another set of SCCs, and in the annex to the decision, we've got the SCCs themselves. So we have, in a PDF you can download, a set of SCCs. Some of the provisions are generic, they apply to all the modules, and then for some you'll see, this is for module 1, controller to controller. This is for module 2, controller to processor. So we've got all the building blocks. But if the question from Jacques is, are they just going to give us a nice Word document that's just for module 1? No, I think probably we've got the work to do to create the document that has the right modular elements for the transfers that we're doing. So, my vendor clients, for instance, who are usually processor importers, will have, reflecting module 2 or 3, they'll have those controller to processor, processor to processor modules built into their SCCs, and they'll just ignore the controller to controller and the processor to controller elements.
Yeah.
So you have to build your own contracts case by case. And as Mareike already referred to, I'm sure there will be standard contractual clause generators available. Actually, a colleague of ours, David Klein, it's a small little legal tech idea Taylor Wessing likes to have, has already done something like this. And when we send out the slides, there will be a reference to that SCC generator. And the idea is you put in what you need, and the result is what you have been asking for.
Thank you. So maybe the next question is also very interesting. Will it be possible as a software as a service vendor to have a fixed DPA using the SCCs, and that can be agreed to via URL? And especially thinking of AWS and MS Azure, how to add new SCCs?
Let me chime in for this one. If you are AWS and MS, yes, that might be possible. If not, I don't know. I mean, the fact that AWS and Microsoft are going this way, which is actually the opposite way how it should be, is because they have such a market power. They just say, "This is my contract. I never ever discuss my agreements only with huge clients on eye level, but with the usual customer. This is here is click the box." And you get what applies for you. And maybe when the time is there, I might amend my terms and make it a little bit more accessible to Schrems 2 and to the new SCCs. But I'm sure if you are a smaller vendor and data importer and you want to try the same, and you will face larger EU customers who are in the first place responsible to use these SCCs. So it's always from a controller perspective. So the typical Model 2 situation, controller to processor, the obligation to use the standard contractual clauses for the data export is on the exporter, not on the importer. So they are the one who play the music, and the rest is whether or not you have the market power to say, go away, I'm using my own. What you certainly can do as a data importer, have a very good, let's say, alternative or solution in place, and that's what Chris referred to, that do your homework, get your papers in place, because many clients, more from a sales perspective, are expecting that their providers have everything in place, which is, let's say, adjusted to their product, adjusted to their services with the right technical organizational measures in place. So you can try as an alternative, try to implement that. But on an automatical thing like leave it or not, I don't think that would be the right approach. Chris.
Can I just chip in really quickly? I've got and it's interesting, it's slightly different. My own gut would be that although there's signature blocks, isn't there, at the end of the first annex, I think. So clearly, strictly in the Commission's view, they're at least expecting an e-signature, if not a wet signature. But my own view is that increasingly with the old SCCs, which needed initialing all over the place, increasingly people are pushing those online. So I think I hear you, Axel. I think from a vendor perspective, even smaller vendors, in my view, should be pushing them online through URL. I love to see everything online personally. Slight question mark about whether it works technically, but that never caused a problem in practice. Apologies, just getting rid of another call. That never caused a problem in practice under the old SCCs. And so, yeah, sure, larger customers will say, I don't want that. I'm not taking a URL. I want to print it off, cut and paste it into a Word document. Let's sit down and negotiate. But you still may get a fair proportion of customers who will just sign up, want to see that something broadly sensible is in place and go for it.
Okay, agree, Chris. Agree. If it's, let's say, if the larger customers talking from the EU controller side, if they don't have an own mechanism in place, what I could see is a clash on systems as we have it today when you negotiate general terms and conditions, for example. If you have a large purchase team on the side of the controller client in the EU, and they say, we have now a new process in place. You have to play to our process. I don't trust any other processes. Then you have a clash of online offerings. We will see. But I totally agree. It definitely makes sense also for smaller vendors and importers to offer something like this, to make it easy so that clients in the EU may say, wow, that's a good solution. It's fixed anyhow, so there's no room for negotiation. I click the box and the thing is done.
Maybe to the next question, to Chris. Could you elaborate more on what the slide said about SOC2 and ISO? What standard could you recommend for a high-risk DPA?
Yeah, so the reference I was making to SOC2 was that the way certainly US vendors try and manage audit under the current SCCs is just to say, they float over the SCCs in a DPA and say, you may exercise your right of audit through me providing you with a copy of my annual SOC2 certificate from an independent auditor. And I was just flagging that because there's now a reference to audit, that audit may include inspection at premises and physical facilities, that doesn't align perfectly. So you still may offer it, but you probably need a second alternative. If the question from Olaf is, okay, but what about security measures? What do I need to offer? There isn't a perfect answer there. Of course, as we all know, GDPR says you must have appropriate technical and organizational measures to protect the data. And you need to do that looking at the data, looking at the state of the art, looking at the risks in particular to the processing that you're doing. I have to say, I think SOC 2 for US vendors is great and probably a bare minimum. And although it's painful, the only international standard I've seen that seems to speak to clients from all countries is the ISO 27001. It's a long and expensive process to go through, but I think it does. Well, you know, whether it's worth a candle is a business call as much as a legal one. But that's the one I think that will get, you know, InfoSec at a lot of large customers at least think, oh, good, they've got ISO 27001. There's a comfort point there. Of course, they're still going to hit you with quite a detailed questionnaire. InfoSec generally, Schrems 2 driven, where there's a transfer is here as well.
So maybe with respect to time, two questions, but we will answer all of them. So, but can you just use the new SCCs as the entire DPA, or will they still need to be in annex? So maybe a short answer to that question.
I would say no, instinctively, if provided. And I know, for instance, in Switzerland, their adequacy is going through assessment now. And so adequacy can be reassessed. So I guess you might say, just in case adequacy is withdrawn, shall we push SCCs? I certainly think if I was a Canadian vendor, I'd probably be reluctant to agree SCCs on a just in case basis. So I'm not sure how hard I would push that. Unless, and this is an important caveat in practice, of course, even if you are in Canada or Israel or Argentina or this number of Japan, adequate countries, so often, so much of the tech comes from the US that it's quite rare if you really shine a torch down the chain, you don't find there's some processing going on in the United States anyway. And then as a controller or a processor exporter in Europe, you need to float SCCs across onto the Canadian entity so that they are then reflected down for onward transfers. So quite commonly, the issue is not that the data stays in an adequate country, it's that it leaks out through a series of sub-processors to a non-adequate country, and then you're left in the same position effectively.
So, and maybe one last question from my side, when we think of OS, and you are all OS experts in that way, very often we have use cases where we cannot predict that there will be data processing in the US, for instance, support services. Although I store all my data within the EU, I have data processing in the US because of support services. Or the mother company is in the US and they will also do support for VIT or something like this. How can we deal with these use cases? We cannot change everything and cannot put everything to view. How can we deal with that challenge?
I mean, first of all, also it's maintenance access or whatever, it's a transfer. So wherever you are, if you sit in India, for example, what you often have in the outsourcing arena, and even if they don't look at the data or in question, only if they have theoretical access of the data, that's regarded as a data transfer, and more or less the same rules applies, which is of course burdensome and for many folks not really understandable. But I think on a one-time basis, that's probably you can come away with Article 49. But if it's like a service which is installed there, it doesn't really make a difference if you transfer to India, taking that example, or if you just look from India into the systems.
And I think that goes back to the point as well that I made earlier, that it's not just about the standard contractual clauses, it's also about those internal transfers as well, where you're transferring that data out of the EU. So understanding that piece as kind of part of your overall approach is important.
And then as we have 3 minutes left, and there are still a few questions, just quickly, as I have the time to read that. The one question, shall we have standard contractual clauses with transfers from the EU to Canada on a just-in-case basis, in case adequacy will be gone one day? I would not recommend to do that, because by this, you take on board a TIA, or the TIA would look a little strange, because you can say, well, I do a transfer impact assessment, and it says Canada is an adequate country. Why doing this if you have already a justification for your transfer because there's an adequacy decision? As you know, an adequacy decision is also one of the alternatives to the standard contractual clauses. It makes your life easier. I wouldn't do that on a just-in-case basis. And another question about clause 14, talk about more about roles of exporter and importer with respect to clause 14. What do you think will be in future terms of the assessment? Will both parties have their own? It's going to be a nightmare. That's what I think, and it's going to take a while until everyone is fit on doing so. I think that the importer, I think there will be a requirement in the market that the importer has a TIA ready, because if I would be the controller and I send data somewhere else, I don't want to make a legal assessment in each country. I say, you provider, you sit there and you should know your law better, and you should know more about the transfer in question. Please making sure that you have something neat and clean in place. Then at least this will give you a competitive advantage to those providers who say, I give a damn, it's a controller obligation, I don't care. So I think in the long run, although the main, it's the hot potato thing. The hot potato is in the laps of the controller exporter. It will be more or less thrown to the data importer via questionnaires, via market request, and say, please give me a template for that TIA.
Thanks. So then we will also answer the last question, I think. So do you still recommend using standard contract clauses if the data transfer is from you to a country which is subject to an EU adequacy decision, for instance, Canada, as a precautionary measure in case that a decision is no longer applied in the future?
I think I tried to answer this already. Don't do it. Don't do it because otherwise you have to have unnecessary burden. I would stick to the benefit that you have an adequacy decision in place. The last question I saw here was also, I think, answered by Chris. You are in Canada as a provider, but you have a sub-processor in the US. And then, Chris, as you said, you can say it again, please. Then,
yeah, I think that's the point, isn't it? That you may need the new SCCs with your Canadian importer if the data leaks out to non-adequate countries.
I think so.
And that happens a lot. Last one I can see, can you use the new SCCs as the entire DPA, or do they still need to be in an annex? I think you can put them where you want in the document. So they literally could be, albeit a very long clause, they could be a clause or a section in your MSA. It gives you that kind of flex. I think people will probably still put them into a schedule because they're kind of standalone. They often go to a different team inside companies, and it's probably just easier to see them in a schedule like that. But there's no rule about it.
Okay, so then the last question: what should a UK software as a service vendor do?
They should schedule a follow-up call with Aaron, Axel, and me. We'll be delighted to speak. I mean, I think seriously, I mean, you know, I think it's the planning point, and Aaron spoke to this really well. I think this is a big deal. It's a project with multiple work streams. So you really need to start talking to the executive team, lining up people, getting internal resource from InfoSec, engineering, marketing, sales, and really bringing everyone together and start planning it. I think that oh, sorry, that was a UK SaaS vendor.
Yeah.
Interesting question, not a US. You see, I work so often with Americans. I saw so a UK SaaS vendor. Yeah, that's
the adequacy decision.
Yeah, that's right. It is. Sorry, apologies. Going off on a tangent. I think for a UK SaaS vendor, I think if you should. I think you can probably almost guarantee that you'll get an adequacy decision. I think it would be really, and I know the European Parliament is causing questions, but I think that's predictable. My guess, the other institutions, as they can, will override that, and there will be an adequacy decision. There may be challenges later. It may be that for Schrems and other people in privacy activists, they want to have a pop at the UK adequacy, just that, like they did a privacy shield, which will make life even more interesting, if that's the right word. But of course, a bit like the Canadian example, if the UK cloud vendor has adequacy, but also has sub-processors, say there's a bunch of support engineers in India, or there's help desk out of the Philippines, you know, you see these examples quite often. You've got to make sure if you're going to say, I'm adequate now, so I don't need to worry, that that's true for the whole chain of vendors that sit behind you and also process your personal data. And that's where, of course, in our globalized world, the deeper you go in the chain, the more likely you are to find there's some processing, not just outside the UK, but also outside the EU, and often in the US or in Asia somewhere. So there, if you have that, and I think you need to be ready and doing the work, or you'll get a nasty surprise from the first big customer who really does the diligence and says, oh, hang on, what about these guys? They're not in an adequate country or in the EU.
Yeah. So thank you very much, guys. It was very interesting and also very funny. So yeah, and also for you all, we will send the presentation afterwards. We will get the link of the record. We will publish it on YouTube. We will also provide you with the link to the SCC generator. And yeah, we hope you enjoyed it. And so have a nice day, have a nice evening. And so I hope we will see us soon. Bye.
Thank you. Bye.
Thank you, everyone. Cheers.
Bye. Cheers. Bye.